problem of having something that's a constitutional right within our state, but that the feds still see as a serious felony. For people that have custody issues, for people that have public housing issues, subsidized housing, employment issues, it is still a federal offense to have certain amounts of marijuana, to sell marijuana, to manufacture marijuana, and people that have one of these situations are at risk. That even though they are complying with the laws of the state, even though they are on the list of approved users in the state, they are still committing federal offenses. And
discrimination.
Right, from the point of view of the federal government, it's not discrimination. They say that you're violating the laws of our country. And the Supremacy Clause, as we all know, says that where state and federal laws conflict, the federal law is supreme. It was true in civil rights, and it is thus far true in the criminal context. And you know, I mean, people that have talked about medical marijuana as a civil right, the federal government disagrees, and the current state of things is that notwithstanding the laws of a state, the federal government can still come in and prosecute people within this state if they choose to. We saw that with Mr. Barkowitz. The federal government can still take away government benefits from people who are using this medicine. And that until there is a change at the federal level, this is going to remain a problem. The state cannot, through its own decisions, change federal law. And that is why you know, if we're going to, as we get more and more states approving medical marijuana, we can see things tipping, but the way they're going to tip is not through the states, but in Washington.
There are